Good morning, everyone. A couple of housekeeping items. Please shut your phones off or put them on silence. If you in the gallery want to have a discussion with someone, you're welcome to do that. I'm sure it's important, but please do it in the hallway. I want to welcome all of the committee members and those of you who are substituting for today. I really appreciate you all. And with that, I will ask Representative Alicea to lead us in the Pledge of Allegiance, please. Right behind. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all very much. And with that, I will, I'll open this executive session, and we'll go over all these bills. The first bill of the day is House Bill 1118. Representative Belanger, do you have a motion?
I do, Madam Chair. Motion OTP.
Do I hear a second?
Second. Sorry. Second.
Representative Yokella seconds that. Do we have any discussion? Hearing and seeing none, I will ask the clerk to call the roll.
Representative Renzullo.
No, it would be Yokella first.
I apologize.
That's okay.
Representative Yokella.
Yes.
Representative
Renzulo.
Renzullo. Yes. Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes.
Representative Denise Smith.
Yes.
Representative Long.
Yes.
Representative Alicea.
Yes.
Representative Marjorie Smith.
Yes.
Representative Levesque.
Yes.
Representative Chase.
Yes.
Representative Petrino. I vote yes. And that is it.
Me?
Oh, and the chair. And how does the chair vote?
Yes.
I apologize.
No apology necessary.
Thank you.
With no objection, Representative Long has requested consent.
How many people? Where's the children?
He'll give it to you.
14 0. Okay.
I see no objections, so we will put that on consent. And thank you for that. Our next bill is House Bill 1278 relative to the modification or termination of term alimony. Representative Nelson, do you have a motion?
Thank you, Madam Chair. I do have a motion. My motion is to ITL.
Do we have a second, Representative Belanger?
Second.
We have a motion and a second. Do we have any discussion? Seeing none, would the clerk please call the roll?
Representative Yokella.
Yes.
Representative Renzullo.
Yes.
Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes.
Representative Denise Smith.
Yes.
Representative Long.
Yes.
Representative Alicea.
Yes.
Representative Marjorie Smith.
Yes.
Representative Levesque.
Yes.
Representative Chase.
Yes.
Representative Petrino, I will be voting yes. Madam Chair DeSimone.
Yes.
The vote is 14-0.
Representative Long has requested consent. Do I see any? Representative Chase? Representative Chase seconds that. Without objection, this bill will go to consent. Thank you, Representative Chase, and thank you, Representative Long. Good morning, Representative Altshuler, and welcome. Yeah, all rise. Without objection, we'll give Representative Altshuler a minute to get settled. All set, Representative? Good. You're very welcome. The next bill will be House Bill 1279, relative to the duration of term alimony. Do I hear a motion, Representative Nelson?
Yes, thank you, Madam Chair. I motion to ITL.
And do I hear a second?
Second.
Thank you, Representative Belanger. Will the clerk please call the roll, since I see no hands for discussion?
Representative Yokella.
Yes.
Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes.
Representative Denise Smith. Representative Long.
Yes.
Representative Alicea. Representative Marjorie Smith. Representative Levesque.
Yes.
Representative Chase. Representative Altshuler.
Yes.
Representative Petrino. I will be voting yes. Madam Chair DeSimone.
Yes.
That
You
is
forgot
15 to
Representative Renzullo.
Oh, Representative Renzullo, I apologize. And you were voting yes.
Welcome.
And that is 15-0.
Representative Long, Representative Long requests consent without objection. Representative Alicea has seconded that. Do I see any objection? Consent it is. You ready? Okay. Our next bill will be House Bill 1280, prohibiting a parent's refusal to vaccinate a child pursuant to an order of the state or federal government to be used as a basis for terminating parental rights. Do I hear a motion, Representative Yokella?
I motion OTP.
Do we have a second? Representative Belanger. Representative Nelson.
I second.
Thank you. Representative, is there any discussion?
Sure.
Representative Long.
Thank you, Madam Chair. On House Bill 1280, it's plural, the parent's decision. There are often times when parents don't agree. So I'm not sure how that would be handled. And then the last line on line 12 has the ultimate decision regarding the health care of children resides with parents. Although I agree with that, I don't know if that statutorily changes what we currently have with respect to a divorced family. If a parent has the health care responsibility, that this would change it to both parents' ultimate decision on health care. So for that reason, I'm going to be supporting the ITL.
Thank you, Representative Long. Yokella, would you like to speak to this bill?
Sure, Madam Chair.
Listen, this is my first day. You got to give me a break here.
It's so I think that really this is really only limited to the termination of parental rights, and so I think that it's only going to come up in those hearings, and so I did think that we had testimony that there was someone that was, maybe it was, I believe back in the 90s, according to the person that I talked to, that had their kids taken and put in foster care. I'm not sure if they were eventually terminated. They didn't actually say that, but that was definitely concerning to me, and so I definitely don't want this to happen, and so even if it is not the current practice, I'd still be supporting making sure it doesn't happen in the future. So thank you.
Thank you, Representative Yokella. Any further discussion? Representative Smith?
Thank you very much, Madam Chairman. I'm puzzled, and perhaps my colleague could explain this to me a little more. He refers to something that he had heard that may or may not have happened in the past, and that usually is not the most reliable information on which we should base decisions. This committee that I served on very briefly at one point, but I have followed its work, and the committee has been unbelievably careful over the years of recognizing the rights of parents in an intact marriage, and also balancing the rights of parents when marriages are no longer intact, and trying to balance the importance of the rights of parents with obligations to protect the well-being of the child. And I've read the bill. I had been told that there might be an amendment, and I was hopeful that there would be one, but there isn't. And based on the way the bill is written, I think it undoes a lot of the work that this committee has worked on so consistently over the years. And I would hope that, absent an amendment, that the committee might consider voting down the OTP motion, and perhaps instead going, I'm sorry, I'll wait till you can listen to me.
I'm sorry, we are listening to you to the point where Representative Yokella has something to suggest. in maybe helping you with your concerns.
Thank you. What I wish, if I could just finish my sentence, what I was going
Sure.
to suggest is that perhaps it might be appropriate at this time for this bill to be referred to interim studies so that it can, in fact, honor the long-time commitment of children and family and also address what is could be viewed as a specific problem. Thank you very much, Madam Chair.
You're welcome. Thank you for your concerns. Representative Yokella, would you like to speak to Representative Smith's concerns?
Thank you. I do so. For your in regards to the testimony that was brought to the committee, it was brought by a former employee of the state, and so I have no reason to believe that her experience in that was mistaken. And I also do remember mentioning that I would be open to an amendment on this, specifically removing as the ultimate decision regarding the health care of the children resides with the parents, crossing that section of the bill out, and just saying a parent's decision to not have their child vaccinated pursuant to an order of the state or federal government or agency or person of the same shall not be grounds for termination of parental rights, period. Might that address some of the concerns that you raised?
Well, thank you very much for the courtesy, Representative. But whether it addresses or not is irrelevant, since my understanding is the deadline on this bill would require us to vote on it now, and there is no amendment before us.
One could be drafted. If it was the will of the committee.
Representative Long.
Thank you, Madam Chair. I mean, I would be more comfortable with that deletion. And I guess I could be okay with the rest of the language, although, you know, it's gonna be a court decision if both parents don't agree with something. And we know how that works out. Somebody's not happy and they come here and let us know about it. But yeah, I having that last sentence deleted would be helpful for me. I don't know.
Would that
what everybody else
bring
thinks.
you to agree with the ought to pass motion, Representative Long?
Oh, wow. Oh. I don't know. What do you guys think? No, I guess not. Thank you.
Thank you. Representative Yokella.
I just wonder if the correction or the amendment would still be of enough value that we postpone till an amendment get drafted later in this day, that it be of enough value that we not vote on it at this very moment and wait for that amendment to be drafted. Or do you think that we should just move forward and maybe do a floor amendment or something like that?
Is it true, Representative Long, that it's not going to change your motion?
Yes, that would be the truth.
Well, with that said, Representative Yokella, before I ask Representative Chase for her question, if you want to make the amendment, we can do that if that amendment is important to you. However, it seems that it's not going to change the vote.
If you want to recognize, in the event of expediency, I think I will just propose that amendment as a floor amendment instead, and so that I think because I actually do think that the change is of value. So, so for that reason, I want it, but I don't want to hold up the committee.
Thank you, Representative. I agree with you, but I do want to hear Representative Chase's concerns.
Actually, it was more on the hearsay, when it might have been answered, about children being taken away from parents because that they were not going to vaccinate them. I didn't get to hear the whole testimony. I did listen. But how often does this happen? And why was the concern of bringing this bill forward? Just quick in a nutshell so I can understand my vote. Thank you.
Yeah. According to the records, it's happened more than once, and as far as I'm concerned, that's too many times. Thank
you.
you. Representative, oh, are you finished? Thank you. Representative Belanger?
Thank you, Madam Chair. And I just wanted to speak to the previous representative's point. There was actually a case this year where DCYF was involved in a parent choosing not to vaccinate their kiddo. I don't remember the exact name or who that person was, but I do recall that being a case most recently, this year specifically.
Thank you, Representative. Any further discussion or questions? Seeing none, I'll ask the clerk to call the roll.
Representative Yokella.
Yes.
Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Renzullo. Yes. Representative Healy.
Yes.
Representative Green.
Yes?
Representative Denise Smith.
Yes.
Representative Long.
No.
Representative Alacea. No. Representative Marjorie Smith.
No.
Representative Levesque.
No.
Representative Chase.
No.
Representative Altshuler.
No.
Representative Petrino. I will be voting no. Madam Chair, DeSimone.
Yes.
Motion carries 8-7.
This will not go on consent.
Yes. So that-
Am I correct, Representative Long?
I,
Will there be a minority report? Thank
the
you.
recommendation will be ITL.
And your recommendation will be? Thank you, Representative.
Long. Okay. Amendment to 1280.
Take your time.
1286. Modification of parental rights and responsibilities. It's me. Yep.
The next bill we will be discussing will be House Bill 1286 relative to the modification of parental rights and responsibilities. Representative Yokella, do you have a motion?
A motion OTP.
Do we have a second?
I second.
Representative Yokella, would you like to speak to your motion?
Or
What is your motion?
Sorry. I
You
want
wanna
to
rescind that?
withdraw my motion and motion ITL. Sorry,
Thank you.
wrong page.
You made Representative Long so happy for a second.
I'm sorry, Madam Chair. This is 1286, correct?
Yes, ma'am.
Yes.
Thank you.
You're welcome.
Do you want to second that, Jody?
Second.
You withdraw your first second,
I withdraw my first second.
and you're going to
second this.
And I'm seconding the second motion. Thank you.
Thank you, Representative Nelson.
Sorry. And did you want, did
You want to speak to this motion, Representative Yokella?
Yes. The sponsor of the bill actually brought us information that said that the Supreme Court already interpreted the current language the way that she's planning to change it so that it could be interpreted that same way. And so the Supreme Court has already issued guidance to all of the courts that this is how it should be interpreted, and so this change is not necessary. Thank you.
So just,
Any discussion? I saw Representative Altschuller's hand first.
Thank you, Madam Chair. I don't remember that particular bit of testimony from the prime sponsor. However, what I do know from having spoken with the prime sponsor is that there is a desire to have the legislation match and guide future orders coming from the court. And this change of any of to only actually provides a specific set of bumpers, if you will, to keep the decision for modifying permanent orders within a particular lane and to not offer spaces for it to go left, right, and sideways. So this was actually like a very, very specific ask to keep judicial constraint within a specific lane. So I feel like it is incredibly necessary. Thank you.
Thank you, Representative Altschuler. Representative Long, you had Representative Marjorie Smith.
Thank you. Actually, that was the point that I was going to make, that we haven't,
Thank you.
over the years, many times, we act as legislators, we pass laws. The courts face cases involving those laws. They see areas where perhaps we could fine-tune the language in order to make sure that intentions are clear in the future. And the usual procedure is to evaluate that and agree. And so I was delighted at the initial motion, made a lot of sense. And now I'm confused. Thank you.
Thank you. Any further discussion? Representative Yokella.
Thank you, Madam Chair. So the Supreme Court doesn't actually make laws, they just interpret it, and so there was, at some point, there was a confusion about the correct way to interpret it, but the Supreme Court clarified that the correct way to interpret it is that the list is limited, and so clarifying the language further just opens up to a new interpretation by the Supreme Court of the language and invites a lawsuit. So I don't think so. I don't agree. So thank you.
Madam Chair?
Thank you. Who's speaking?
You are, because you're in charge.
Who asked
I did.
for my attention?
I did.
Representative Smith.
Thank you. I'm a guest here, and I understand that, and I don't want to exceed my authority, but I listened to my colleague speak, and what he said supports his initial motion, and that is, in fact, we make the laws, the court looks at them. The court doesn't make the laws, but they say where there's a need to clarify. That should be the legislator's responsibility, so that we can clarify and put in place what we want. And I know that sometimes we get attached to one bill or another. I certainly have over the years, or one position or another, but I think his initial instinct was right, and I'd like to go back to that first motion at some point. Thank you.
Thank you for your suggestion. Any further discussion? Representative Altshuler.
Thank you, Madam Chair. I'd like to say that Representative Yokella's initial motion was right on the money because, as you said, it's the judicial branch's responsibility to interpret the laws. And when the judicial branch sees that there is confusion, it is often and regularly brought before us to clean up, to clarify, and to fine-tune spaces where the law has question. So while the Supreme Court may have ruled in a space that perhaps in one representative's opinion makes this moot, I would say that it would do no harm for your argument to make the motion of ought to pass so that the clarification can be put in statute to make sure that we don't have to do exactly what the courts have asked us to do, which is often clarify, consolidate, and make more concise the intent of the law. So we're all on the same page, I think. I think we're all on the same page, and
Thank you.
respectfully would ask for a withdraw of your motion of ITL to OTP so we can all be on the same page together.
Thank you. Representative Yokella, do you have?
Yes. Sometimes when we write laws, they are vague, and the question goes to the Supreme Court for clarification. And sometimes the courts do rule in such a way that they do not, that the legislature, they rule in such a way that the legislature may not agree with their ruling, and therefore the legislation comes to clarify the language so that that ruling, which the legislature believes is incorrect, couldn't be clarified and be pointed in the correct direction. But in this case, the legislature said what they thought was or they made the law. Then a lower court interpreted it in one way, and the Supreme Court says, no, you're wrong, that this is the correct way, and that is the way that this bill is proposed. And so there was once confusion by a lower court, but there's no longer any confusion that it is a limited list by both what we've said in the law currently and what the Supreme Court interpreted our language to be. So this law is just not necessary in the sense that it's already been clarified. And so I agree that the purpose, whether we pass this bill or we don't pass this bill, the policy is the exact same for the state of New Hampshire. So I don't think that in a time that we're having overflow of bills that we need to pass laws or have additional hearings about laws that are not actually going to change policy in New Hampshire. So thank you.
Thank you, Representative. That said, I see no further hands. I'll ask the clerk to call the roll.
Representative Yokella.
Yes.
Representative Renzullo. Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes.
Representative Denise Smith.
Yes.
Representative Long.
No.
Representative Alastair. Representative Marjorie Smith.
No.
Representative Levesque.
No.
Representative Chase. Representative Altshuler.
Nope.
Representative Petrino. I will be voting no. Madam Chair,
Yes.
the vote is 8-7.
Will you be turning in a minority report, Representative Long? Will
Yes.
anybody?
Yes.
Representative Altshuler, okay, thank you.
And the motion is OTP, right?
Representative Altshuler,
For-
what will your motion be
No,
in your
for
report?
motion is going to be OTP, right? Okay.
Mhm. Thank you. Thank you. I'm giving everybody a second to get caught up. All set? You all set? You all set on for 1305? Thank you. Next, I will accept an emotion, a motion on House Bill 1305 relative to temporary alimony. Representative Yokella, do you have a motion?
Yes, I motion OTP.
Do I hear a second?
I second.
Representative Nelson seconds that. For Representative Yokella, would you like to speak to your motion?
Yes, I agree with this bill that temporary alimony should be calculated the same way as regular alimony. I'm not sure why there was ever a difference, and I think that the time spent paying the alimony should count towards the time being spent allowed for the total amount of time spending paying alimony. So I think that this is a good bill. Thank you.
Thank you, Representative Yokella. Any discussion? Representative Long.
Thank you, Madam Chair. We all received an email from Attorney Hastings, who's been in this field forever, has an attorney, family courts, and has a mediator. I think this opens up, for example, the alimony has only been placed within the past, I want to say 5 years, maybe 4 years. I printed out her email, I don't have it on me. So I think changing it, it's my understanding it's been working. I don't know what this addresses. I was here for the testimony, and they're just the introduction from Representative DeSimone. So I don't know where this helps, and I think it has the potential to hurt with respect to temporary. Somebody. I don't know if this addresses when somebody is getting alimony and goes into a relationship, or gets remarried, ends up in a divorce, comes back after 6 months, and they still have 3 years of the prior alimony. Would that kick in? Are those addressed in this bill? Sure.
I don't believe that they are within the scope of this bill, and I just wonder why we have the normal calculation for alimony, and then an additional temporary calculation which does not need to use the normal calculation. Like, what is the purpose of having the why can't they just use the calculation? That's my question.
And that was the purpose for the bill. Thank you. Representative Altschuler, do you have a question or discussion?
Did I turn? Oh,
Thank you. Any further discussion? Seeing none, I will ask the clerk to call the roll.
Representative Yokella.
Yes.
Representative Renzullo. Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes.
Representative Denise Smith.
Yes.
Representative Long.
No.
Representative Alsea. Excuse me, I apologize. I said Representative Alsea. I meant to say Alsea. I apologize. Representative Marjorie Smith.
No.
Representative Levesque.
No.
Representative Chase. Representative Altschuler.
no.
Representative Petrino, I will be voting no. Madam Chair Desimone.
Yes.
The vote is 8-7.
Will there be a minority report? Beck. Okay.
The motion will be ITL.
Thank you. Next, we'll open House Bill 1382 relative to the presumption of shared parenting in the determination of parental rights and responsibilities. Representative Yokella, do I hear a motion?
I motion OTP.
Do I hear a second for that motion? Representative Belanger?
I guess I second.
Thank you.
Madam Chair, is Representative Yokella then not bringing forward his amendment?
He will, once we get through the OTP motion.
So
I apologize. I've never been on a committee where you don't first vote on the amendment and then
We will.
But
That's okay, thank you. Representative Yokella,
thank
you are
you.
recognized.
Thank you. I would like to move amendment 2022-0887H.
And you should all have a copy of that amendment. And now I'll ask for a second. Can you use your
Second.
words? Thank you. Representative Belanger has seconded the motion on the amendment 2022-0887H. Representative Yokella, would you like to speak to your motion?
Yes, thank you. This amendment just wipes out the entire bill and replaces it with a definition of shared parenting, where each parent plays substantially equal role in decision making, and 35% or more of the child's residential time is spent with each parent. And then it also places inside of the parental rights and responsibilities where under section I-A, there is a section that reads that if the court concludes that frequent and continuing contact between each child and both parents is not in the best interest of the child, the court shall make findings supporting that order. And so all we're doing is adding the language that if the court doesn't make that conclusion, that there should be a presumption that shared parenting is in the best interest of the child. So there is still kind of judicial leeway as far as one deciding that that contact between both parents is not in their best interest, and you know, even in the current law right now, we already recognize that contact, if the, you know, there's no harm to the child in doing so, that contact between both parents is best, and all the and a bunch of research that I'm aware of suggests that that is best for the social and emotional relationships that child forms in their youth is beneficial by contact with both parents if they're not harming their child. And so I believe that this makes it clear that that the court can still say that it's not the best interest of the child if there's reason to, but otherwise we should try and move towards both parents being a significant part of that child's life. So I hope that you will support this amendment. Thank you.
Thank you. Any discussion?
Sure.
Representative Long.
Thank you, Madam Chair. So although I do agree with the representative that both parents are the best case scenario, that's not often the reality. The current customized parenting schedule approach appears that will be gone. And this is important where there's more than 2 children involved, because there may be a parental schedule that suits one and may not suit the other. So I think this, I think this is rigid as far as the scheduling goes. It's, I know you also say if the court does not make that conclusion, so the court would have to make that conclusion, that they could put it back to a customized, to a current scheduling that is current? Is that what that last sentence says? I mean,
Thank you. So currently they're already making that determination. This is already in law, right, where they can determine that that the child should not be with one of the parents, and the language added is just that there shall be a presumption. Obviously, if there is evidence that that is not the case, then the presumption would be overturned, right?
so a follow-up if I may?
Follow up?
Yeah, so what changes? The judge needs to put in writing or something to where, I mean, I'm trying to figure out what changes with this being passed. Doesn't appear that anything's changed.
Thank you.
Representative Yokella.
Thank you for the question. So the change is if they don't believe that it's going to be harmful to the kid to have relationships with both parents, that their starting point should be that they have relationships with both kids in a significant amount of time, and not just like one day every month or 1 weekend a month kind of a thing. It would be more substantial than that, unless they have reason to say otherwise.
Okay. Thank you.
Thank you. Representative Altshuler.
Thank you, Madam Chair. My deep concern in establishing my deep concern is that this is a this is a very subtle but impactful place where this is not about the best interests of the child, but the best interests of the parents. And I'm very concerned that for families that experience domestic violence, that this creates a space that there is a presumption that shared parenting is in the best interest of the child. And we know from court decisions that have been made that decisions that affect two adults' relationships often hurt the children involved. And that I think that this creates a space where the parents' conflicts will take precedence over the best interests of the child. I don't see a carve-out. I don't see any acknowledgement that that this is about the children. This is mostly about the rights of parents and not about the best interest of the child. So if Representative Yokela, if you could explain how this protects children in the spaces where domestic violence happens, I want to understand this better.
Thank you. Representative Yokela, would you care to respond?
I would just point you to lines 11 and 12 of the amendment.
Thank you. Any further discussion? Representative Altschuler.
Thank you very much. I read 11 and 12, but that doesn't answer my question, which is how? It's incredibly vague, doesn't address domestic violence in any meaningful or significant way, doesn't mention abuse, it doesn't mention, convictions, it doesn't mention restraining orders, it's just very vague, so I don't understand how that particular language is protective. And
Thank you.
Does it refer to another space in law that I am missing? Because I have 461A up, and I just...
Thank you. Any further discussion? Seeing none, I'll ask the clerk to call the roll.
Voting on the amendment. Representative.
That's correct.
Representative Yokela.
Yes.
Representative Renzullo.
Yes.
Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes.
Representative Denise Smith.
Yes.
Representative Long.
Yes.
Representative Alicea. Representative Alicea.
I apologize. I'm having such a difficult time. I'm rereading it and rereading it. I apologize to the committee.
You can come back to
Okay.
it.
All right, I'll come back to you.
Would you like the clerk to come back to you, Representative?
Yes, please.
Certainly.
Representative Marjorie Smith.
Yes.
Representative Levesque.
Yes.
Representative Chase.
Yes.
Representative Altschuler.
No.
Representative Petrino. I will be voting yes. Representative Alicea. Madam Chair. just a
Yes.
moment. Okay. 13-2. The amendment passes.
Representative Yokela, do you have a motion?
I move OTPA.
Is there a second to that motion? Representative Belanger seconds.
Second.
Thank you. Any further discussion? Seeing none, I'll ask the clerk to call the roll.
Representative Yokella.
Yes.
Representative Nelson.
Yes.
Representative Renzullo. Yes. Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes.
Representative Denise Smith. Yes. Representative Long.
No.
Representative Alicea. Representative Marjorie Smith.
No.
Representative Levesque.
No.
Representative Chase.
No.
Representative Altshuler.
Nope.
Representative Petrino. I will be voting no. Madam Chair DeSimone.
Yes.
The vote is 8-7.
Will there be a minority report? And what will your motion be in that report?
It'll be ITL.
Thank you, Representative Long. Representative Altshuler.
Yes, Madam Chair.
I apologize. I was just alerting Representative Yokella that you will, in fact, be writing the minority report.
Indeed, thank you.
You're welcome.
Okay.
That is being addressed immediately. Thank you. I am too, with no disrespect to anybody. I'm putting my hands over here and, yeah. Okay, can we have some order here and we'll go on to the next bill, please? The next bill is House Bill 1396 FN relative to the payment of child support. Representative Nelson, do you have a motion?
Yes, thank you, Madam Chair. Motion to ITL.
Do I have a second?
Second, Madam Chair.
Representative Belanger seconds Representative Nelson's motion. Representative Nelson, would you like to speak to that motion, ma'am?
No, thank you.
Do I see any discussion? Representative Long?
Thank you, Madam Chair. We've heard testimony and received documents with respect to the court will say that child support is owed at $100 a week, effective 11/1. And then we're hearing of people receiving the support, not receiving the support, and not receiving the support for 2 or 3 or sometimes 4 weeks until they go back to court because the person that's supposed to be paying says it wasn't defined when I'm supposed to pay. I was supposed to pay November 1st, and that's all I paid. It doesn't say I got to pay every week after. That's the fact that's happening now. So this is a simple fix that when the judge makes the decision, put in the payment schedule. Every beginning of the week, effective November 1st, or what have you. That is currently going on now, that people that are supposed to be receiving this child support are not receiving it. They're waiting to go back to court to get the judge to give a schedule. And that's hurting people that ought to be receiving their child support in a timely manner.
I'm sorry, thank you. Any further discussion? Representative Chase?
Thank you very much, Madam Chair. And Representative Long, I think you know my ex-husband. So this is this is great, because that was always the clarification. So I'm going to agree with this. I thought, like this bill, I think it's clarifies exactly when. There are so many good parents out there who pay and take care of their children, but there are also those others that, well, it wasn't said, and I'm going to pay when I want to, or you're going to have to keep dragging me back to court. That is a real issue with childcare, while you have to go to court to try to get the little bit of money that's supposed to be paying for these kids. And my own personal experience, I love this. I think it's a great bill. Thank you.
Thank you, Representative Altshuler.
Thank you very much. I, at the risk of dating myself a little bit, used to be a time when you would make a purchase, take out a loan, have a financial responsibility that came along with it, a set of stubs that you would fill in the date, write a check, stick that stub in, it had a number on it that would refer to the payment that you owed in whatever venue it was. And we don't do that anymore. However, particularly, it would be super helpful in the courts because we heard testimony and we know that without very clear and explicit instructions, we have a significant number of granite staters who will look for any and all loopholes to not pay what they owe for their child support. So this would give a specific time frame that child support is due on a specific date. And when it doesn't come through, that gives the person who is supposed to be getting that child support to pay for those children an opportunity to go to court and say a deadline has been missed without having to get involved with all the nonsense that is happening right now with people who are supposed to be paying saying, well, it wasn't really clear. We couldn't be more clear if we just put in a payment schedule. Thank you.
Thank you. Any further discussion? Representative Yokella.
Thank you, and thank you for recognizing me. I agree that it is a good practice. I, however, have concerns that if someone's situation is fluid, they may be looking for a job or in between jobs, that payment, let's say on the 15th and the 30th of the month, may not be appropriate in that new situation, and the courts may have to hear a case to try and change the due date. And so I believe that while it's good practice, there's nothing barring the courts from doing this now by saying that, and it leaves all open the option for them to not specify it in cases where it is that specifying it would only create more work for them in the future. So I agree that it's good practice, but I'm not sure that legislating it is the best solution. So thank you.
Thank you. Representative Petrino.
Thank you, Madam Chair. Regarding this discussion, to your point, Representative Altshuler, if you have car payments to make, the bank expects that you make your payment regardless of whether or not you can pay or not. And really, child support is much more important than making monthly car payments. So that's just my 2 cents on that matter.
Thank you. Representative Long.
Thank you, Madam Chair. So if you lose your job or you just got your wages knocked down, you notify the court. So you notify the court right away. So the court knows that why this payment didn't come in. And also, again, we're looking at I'm getting mixed messages, just the world according to me, or this committee according to me. Judges' discretion, which some bills we absolutely do not want the judges to have the discretion. And then some bills, well, leave it up to the judge's discretion. And I think the court system, I've heard this before, probably when they came before us an organizational day, that they prefer that the legislation be clear. You know, that's what they prefer, because it's, you know, and it makes sense to me if I'm a judge, which I don't qualify whatsoever. But if I was, I would like to be clearer with legislation and not having it interpreted. So, you know, in this case, to having the judge's discretion, this is a simple, why not, you know, why not make it statutorily required?
Thank you, Representative Belanger, and then Representative Smith.
Thank you, Madam Chair, for recognizing me. I think one of the things that I've recognized in this committee is that we hear all sorts of situations when it comes to child support. There's no set scenario that is perfect. When the issue that I have is that these things should be worked out in the courtroom. It shouldn't be a requirement that you have to pay it on this day at this time. It should be a payment, but unfortunately, I think this bill is just not the best, and I think it can be done a little bit better, which is why I support the ITL motion.
Thank you, Representative Smith.
Thank you very much. I cannot tell you how much I am valuing my experience here with this committee today, because I learned so much from seeing how other committees function. But I have to admit that I'm confused in that, again, going back to something that Representative Altshuler says, I'm old enough to remember a song that said, first you say you do and then you don't. First you say you will and then you won't. And what I hear is agreement about the importance of child support, the importance of having a court make a reasonable, rational decision about how that child support should be paid, and then the music stops. Because then what I hear is someone or another saying, well, yes, the court makes the decision and they say it should be paid every week or every 2 weeks or every month and it should be this much. But if that's not what happens, so it's what doesn't happen, requiring then the aggrieved parent to go back to court and to start all over again. And if we all agree that, I mean, I won't tell you my principle that nobody in the world should be allowed to have children unless I agree that they in fact would be good parents. But I'm going to let that one go. I mean, you know, just for the moment, I'm going to let that one go. But things happen and marriages break up after children have arrived on the scene. The state has a responsibility for the well-being of those children, and we have a court system to enforce that. And when the court says A, B, and C, that ought to be the rule. And if circumstances change, and they do, people lose a job, or they get a job that's going to require them to move out of state, or all kinds of other things happen, you then can go back to court and say, please revisit the decision because the circumstances have changed. And if the circumstances haven't changed, well then you ought to follow the court. And on this one, again, I hope that I'm so upset. I'm always upset when I see partisan votes. I just don't see things in a partisan way. I never ran a committee's partisan. And I see people questioning things that are said, but still voting in a way that they think maybe they're expected to. I'd like perhaps this one to be a bill, since we have consensus in the importance of supporting children, which is what child support is about, that we recognize that we ought to make it easy to be able to know what's expected and to expect people to follow what's expected. And so I hope we might not accept the pending motion and in fact recognize that this bill does what I think we all want to have happen. Thank you, Madam.
Thank you. Representative Alsea.
Thank you, Madam Chair. My concern is, I just feel like it reads as in the interest of the parent. So do you say to your child, the parent that's supposed to pay isn't able, there's no schedule for your other parent to pay. Therefore, I can't schedule dinner today. So I'm having a hard time. I apologize again. We're all here for children. And it just feels like we're making it comfortable for adults. That's a statement.
Thank you.
Okay, thank you.
Representative Altshuler.
Thank you very much, Madam Chair. So I think I am also deeply uncomfortable because we have rules and we have laws in the state of New Hampshire about paying our bills and paying them on time. And if, for instance, you owe money on a car and you don't pay that money on the car, you can have that car taken away in less than 90 days. 90 days and there is firm action. But if you don't pay your child support, you can be in arrears for more than a year. You can be in arrears for over $10,000 before the courts take swift action. And I would say that 1 year is not necessarily swift action. There are spaces where the court can put a withholding on a paycheck. And I will say that I have worked with parents for whom the other parent of their child specifically stays underemployed or works for money under the table, so there's nothing to report, and then claims, I don't have any money. And also, they also don't have a schedule that they have to pay on because their first payment was due on December 1st, and then it says nothing about when the actual next payment is due. So we go through the parents who are paying for their children's diapers and medicines and shoes and the rent on the apartment and the heat, are left twisting in the wind because we have negligent parents who are using these loopholes that we can just close up super easy right now to jump through, which no other financial obligation would allow for. Not one in this state. So I would hope that we can pass this to protect the parents who are trying to care for their children. They can't, as Representative Alsea said, say we're just, we're not going to have Wi-Fi. I know you have homeschool this week, but we're not having it because we don't have enough money.
Thank you.
So, yeah.
Thank you. Any further discussion? Representative Yokella.
Thank you. I believe the previous representative hit the nail right on the head, that the problem isn't that the courts can or cannot or should not put the due date in the system. The problem is enforcement, and when enforcement is happening. And so I absolutely agree that a bill which maybe does not allow for a year of arrears and $10,000 before we do anything about it is to change that to a lower amount or 90 days or whatever. I believe that is cutting right at the heart of this issue, whereas I don't believe it's actually the judge's fault for lack of clarity that the payments are not coming in. But I believe, in fact, that you kind of have pointed out that their hands are tied because they're not able to enforce it until far past when it should be enforced. And so I think that this is not the solution, but I agree that a bill addressing the ability to go a year or $10,000 is something that the legislature should address going forward. Thank you.
Thank you. Representative Chase.
Madam Chair, I apologize, but I did have my hand raised.
I apologize, I did not see it, Representative. I will ask you to,
Representative Yokella saw me with my hand raised.
I'm sorry, I did not. But I will entertain your discussion after Representative Chase, whom I've already called on. Representative Belanger, you have.
Thank you. I apologize, Madam Chair. I thought the
No
representative
apology
to your
needed. Go
your
on.
right had mentioned something. So, the two previous speakers ago mentioned that you 90 days your car payment company, your bank might repossess your car. But one of the things that you can do is contact the bank and ask them, hey, I can't make my payment this week. I need to postpone that payment. So I'm not disagreeing that child care payments we should close the loopholes. I agree with Representative Yokella when we say that the enforcement is the problem. Now, if I have to pay my child care payment on the 15th and have not had it removed from my check by my employer, which as an employer, I have an employee who does have that withdrawn because of that reason, and they're not doing their responsibility to make sure that it's being done, which is their responsibility to do, but I can't make the payment on the 15th because I'm working paycheck to paycheck, and I have to go and file every time with the court, just becomes a redundancy. So I'm just going to go back to what the previous speaker said, Representative Yokella, about the enforcement of the problem, and I just, again, support this ITL motion, and I hope we can all find a better solution as we continue to move forward through this legislative session.
Thank you. Representative Chase.
Thank you, Madam Chair. It is a step in the right direction. I completely agree and understand with what everybody's saying. I've first-handed went through this for years with my children and having to drag my ex-husband back to court. I understand how much more it costs me. I know the fact of not being able to do things for my children because I didn't have the funds because their father wasn't holding up his end of the deal. All this is just adding a structured payment plan so that person says, oh, okay, this is when I need to have this done. And it's written, and I feel it very strongly, because he had his wages garnished as well, that I could have gone back into court and just said, here's the schedule, and this is what he's doing, and this is what he's missed, and have him be held accountable for it. It's so simple, and I do agree about the other changes in a loss. I think that's something that would be great for somebody to bring forward in the next session. I just don't see ITLing this at all. Thank you.
Thank you. Representative Petrino.
Yeah, thank you very much. Every month we have bills to pay, and we prioritize what's most important. So I have to decide whether or not I pay my rent, if I pay my cable, if I pay for my Wi-Fi, my car payment. First and foremost, the first thing that I pay for should be my child. And so even though my circumstances may change from month to month in terms of my income, I still have all these bills to pay. What's the first bill that should be paid? Pay for my child. Make sure that kid eats. That's my first responsibility. My cell phone, that's secondary. Okay, so again, children first.
Thank you, Representative. I will now ask Representative Petrino, our clerk, to call the roll.
Thank you, Madam Chair. Representative Yokella.
Yes.
Representative Renzullo. Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes?
Representative Denise Smith.
Yes.
Representative Long.
No.
Representative Alisea. Representative Marjorie Smith.
No.
Representative Levesque.
No.
Representative Chase.
No.
Representative Alcala.
No.
Representative Petrino. I will be voting no. Madam Chair, DeSimone,
Yes.
8-7.
Will there be a minority report? Who will write the minority report? Representative Long, and what will your motion be? That is the motion. Thank you. I think you should. We would agree. And on that note, we'll begin House Bill 1416, which it looks like we may agree.
Would-
Yes,
Would it be
Representative.
okay if, now we probably do a group hug before this one?
Kumbaya. Representative Yokella, do you have a motion?
I motion OTP.
Would you like to speak? Oh, do I have a second?
Second.
Representative Nelson seconds that. Representative Yokella, would you like to speak to that motion?
I motion that we adopt amendment 2022-0881H.
Wait a minute. 871. That one.
Oh, it's the other paper on my.
It's nice to know that you can make mistakes too.
Sorry about that.
don't
That was for the
often do
wrong bill. Yes, motion 2022-0871H.
And would you like to, do we have a second on that?
Second.
Seconded by Representative Nelson, and would you like to speak to that motion, Representative Yokella?
Thank you. My amendment just changes the phrase within 30 days after, or within 30 days, and changes it to before treatment begins. And there was definitely concern in my part that someone may get that treatment and then the person paying for that treatment may find out about that treatment only by the bill before it was ever required to be mentioned to that person. And so I thought that was just going to create additional tension, and that we even in emergencies you could reach out and tell the other person that you're on the way to getting treatment. And so I believe that this will reduce acrimony while still reaching that same goal of trying to get that child services as soon as possible. Thank you.
Thank you, Representative. Do we have any discussion? Seeing none, I will ask the clerk to call the roll on the amendment.
Representative Yokella.
Yes.
Representative Nelson.
Yes.
Representative Renzullo. Representative Belanger.
No.
Representative Healy.
Yes.
Representative Green.
Yes?
Representative Smith.
Yes.
Representative Long.
Yes.
Representative Alicea. Representative Marjorie Smith.
Yes.
Representative Levesque.
Yes.
Representative Chase.
Yes.
Representative Alchala.
Yes.
Representative Petrino, I will be voting yes. Madam Chair DeSimone,
Yes.
14 to 1 on the amendment.
Do I hear a motion from Representative Yokella?
I move OTPA.
Do I have a second on that motion?
Second.
That's seconded by Representative Nelson. Do I have any discussion? Seeing none, I'll ask the clerk to call the roll.
Representative Yokella,
Yes.
Representative Renzullo, Representative Nelson,
Yes.
Representative Belanger,
No.
Representative Healy,
Yes.
Representative Green,
Yes?
Representative Denise Smith, Representative Long,
Yes.
Representative Alasaya, Representative Marjorie Smith,
Yes.
Representative Levesque,
Yes.
Representative Chase, Representative Alchala,
Yes.
Representative Petrino, I will be voting yes. Madam Chair DeSimone,
I'll be voting yes.
14 to 1.
Can it go on consent? It has a fiscal note. Okay, right. Thank you. Without objection, this bill will go.
Objection.
Representative Belanger objects, therefore it will not go on consent. Do you want to do a report?
Yes, ma'am.
I'm just waiting for the clerk. Next, I will hear a motion on House Bill 1431, establishing the Parental Bill of Rights. Representative Yokella, do you have a motion?
I motion OTP.
Do I hear a second?
Second, Madam Chair.
Seconded by Representative Belanger. Representative Yokella, would you like to speak to that motion?
Yes, I'd like to move Amendment 2022-0881H.
Do I hear a second on that?
Second, Madam Chair.
Representative Belanger seconds that motion. And Representative Yokella, would you like to speak to your motion?
Sure. This amendment was worked on to clean up what I and some in our committee. I don't know. Yeah. I worked with this with Representative Nelson, and we had some concerns with the language that I'm sure were apparent at the hearing, and I believe some of those were best served by kind of reducing the scope of this bill because there was too many issues to try and get right all in one shot. And so my hope is that reducing the issues make this bill tighter and cleaner and reduce the the conflicts in the hope of getting this positive recommendation. And the main thing that we wanted to do was to remove the medical languages, because we believe that was that most of the testimony that we heard about the issues in the state were regarding actual schools and not as much about the medical issues. And so I believe that we have the time to get the medical issues right before moving forward with that. And there's also a concern of people being able to go to jail, or so we removed in the violation. Yeah, we removed the Class A misdemeanor to a Class B misdemeanor, which does not have any jail penalty possibility, and also removed the removal of the teaching credentials for a year, and remove that to just say that they would get a disciplinary letter in their personnel file, and not for any teacher, school employee, or administrator that violates the provisions of this. So for the and also we clarified that as far as obtaining records, the record request which should be going to the superintendent, and they would be responding in 10 business days. And that's actually longer, I believe, than the 91A. So that should not be a problem. And I think that hopefully I'll try and do more clarification if it's needed. Thank you.
Thank you. Do I see any discussion? Representative Long.
Thank you, Madam Chair. Yeah, we had a good hearing. I listened, and the representative's absolutely correct. I heard from all the testimony maybe one sentence of healthcare. The rest was on education. So I think, in my opinion, throughout the hearing and trying to swallow this, I'm thinking, when were parental rights taken away? I keep having a hard time getting that clear in my mind. I looked through some of the town meeting warrants. These same issues are on warrants at town meetings. I think that's the way to go. Manchester, for example, all that they were looking for is on the website. There are other municipalities that have that on the website. So it's not a state as a whole, every municipality in the state as a whole that we're fixing here. It's specific to some districts that, for whatever reason, aren't giving people what they ought to be giving people, that is currently in statute. When you look at, thank you, Ms. Dyer, for the side-by-side. So I don't know what this is going to do, putting it in statute again. It seems like it's going to be the same issue. And then I also have an issue with page 1, line 18 through 23, and then 25 to 26. So I'll give you an example. As a parent, somebody put in a complaint that my child was being abused. So DCYF comes to visit me. I don't allow him in, because this is my right. I got parental rights. This is my right. You prove to me that my child's being abused, even though the child is being abused. You prove to me that there's abuse, and then you could take that child. But right now, with these parental rights, no, you can't you do the investigation and you show me where there's abuse, and then I'll comply if I even will. So I do have an issue with that. So I think this is, with respect to the schools, this is for the schools to decide. And the infringement on parental rights prohibits any political subdivision, and it names off, and then also the parent of a minor child in this state without obstruction or interference with the state. And again, this is a parent. It's singular, it's not plural. So in a healthy home where there's both parents, what if one disagrees? Who has the parental rights? We heard in testimony, somebody recommended we go to court. Again, let's send everybody to court. And we know what happens there. So thank you, Madam Chair.
You're welcome. Thank you. Representative Belanger.
Thank you, Madam Chair. And I had some of the similar, for recognizing me, sorry. So I had some of the similar concerns that the previous speaker had, which is why I had requested that on page 3, lines 36 through 37, specifically include RSA 169C, which is the abuse and neglect statute. So it says, authorize a parent of a minor child. This chapter does not, specific emphasis on not, authorize a parent of a minor child in this state to engage in conduct that is unlawful, which will abuse or neglect his or her minor child in violation of general law, as defined in RSA 169C. So I think for me, this satisfies my concerns, and I support the OTP motion.
Thank you. Representative Smith.
Thank you, Madam Chair. Following up with Representative Long, I had that happen to me. I have a child with disabilities, and the principal of her school called DCYF on us, and we didn't have a choice to let DCYF in our house. My child has separation anxiety, and she had missed several days of school, several meaning 70, and I can't get her to school some days. And I'm the mother that leaves her kids screaming in the parking lot and leaves there crying hysterically that I'm the worst mother in the world. But my child has disabilities. And this principal had no right to call DCYF. She did not speak to anyone on my daughter's IEP team. She just looked at her attendance schedule and called DCYF. And when we went to discuss this with her, her option to get my daughter to school was to call the police and have the police come and help her get to school. She was 6 at the time. So, needless to say, this does happen, and this happens to good parents. And I got the letter that said I am a good parent because she dismissed the case. But it does happen, and it was awful.
Thank you.
Thank you for taking my question.
Any further? Representative Long.
Thank you, Madam Chair. And absolutely, I do believe it does happen. I've heard several from my constituents where it was unfair. I get that. But on this committee, we got to look at the $20,000, at the 20,000. I thought well, you guys aren't getting 20 grand to be here? Yeah, at the 20.
Only you and I, Representative.
Yeah, at the 20,000, level. And although bad things happen to good parents, what I'm more concerned about is bad things happening to children because of bad parents. So that's what I try to look at. Is there some incidental, what do they call it? Collateral damage type of stuff. I look at one child being harmed. I'm on that page. And with respect to with respect to the language of 169C, these are both 169I, so I don't know if that would go to this. I don't think it would it? Yeah, on first page 18 and 24, 169 I4 and I3. And then we're referencing this chapter does not authorize, has defined in 169C. So is that a misprint?
No, 169C is where the
Includes
they
169I?
define abuse and neglect. And that's where you would get your rights terminated. All of that is in 169C. 169I is a new section that we're adding right now.
Okay. Okay, so with respect to...
Follow-up?
A follow-up, if I may? Thank you.
Certainly.
With respect to the state or any of its political subdivisions, that does not affect when it comes to abuse and neglect. Is that what you're saying?
Representative Yokella, would you
Thank you.
like to respond?
Thank you. So I would just point you to all of the exceptions, not just that one on the end of page 3, but it continues on page 4 that says it does not prohibit the court of competent jurisdiction, law enforcement officers, employees of the government agency that is responsible for child welfare from acting in his official capacity within reasonable and prudent scope of his or her authority, or prohibit the court from issuing orders that otherwise permitted by law, including limits on some or all of the items listed in this chapter as justice may require. So I believe that there is a lot of latitude for the law enforcement or child welfare protection to be able to still do what they need to do with this those exceptions being explicitly stated.
Okay.
Thank you.
Follow-up, if I may, just quick.
Follow-up?
So when it says, so 169 I3 and I4 is not the fact. Shall not infringe doesn't mean it's, any political subdivision shall not infringe is not the case, right? And I think that's what we were hearing in testimony, is what the people that testified wanted. But now we have these two, adding these two sections, however, waiving police, DCYF. I mean, is that what we're doing?
Representative Yokella.
Thank you for the question. So this bill is not intended to give parents like carte blanche to do whatever they want, right? This bill is a mechanism to encourage the schools to have continued dialogue with parents, and that they are not so you don't have a fundamental right to harm your children or any other crime against the children or anything that's not currently allowed. And this chapter says that it is not authorizing parents to engage in unlawful conduct. So I don't believe that this is opening up and giving exceptions to things that are currently not allowed. It's just clarifying so that parents have a place to look at what options that they do have, and it encourages them, especially because you're talking about like schools trying to post stuff online, there in the 169.5 there is essentially a directive that the school boards have policies regarding the options of these parents, and then it also requires that they have procedures for a parent to learn about the additional things that they have in statute, options that they have in statute, including access to the instructional material and such. So it's more of encouraging them to have a policy and think about how they're going to disseminate or either disseminate the information and or educate the parents that they have the ability to, they have the choice here and that they are free to exercise it. And and so that is really the thing that I see of value in this, and not that it's giving them more rights than they currently have now, but making sure, just like we, have the right to remain silent, we still tell the people they have the right to remain silent when we arrest them. It's not that they didn't have it before we told them, right? We just are reminding them, hey, you have this opportunity to exercise it, right? So thank you for the question.
Thank you. All set.
Madam Chair,
Representative Alisea.
thank you very much. Representative Yokella, I understand, I think.
Representative, can you move the mic a little closer? We want to hear what you say. Thank you.
Can you hear me better now?
Yes, thank you.
Okay. Representative Yokella, I think I understand what you're trying to say. I was on the school board for 19 years, 8 of those years as a policy chair. And on our website, every single policy that we put forth included information about parental rights. And anything that you could think of was on there. And in the committees, once we would go through how we felt about dealing with the children and the policies, we would then underneath write what the parents could do, what their rights were. And after 19 years, I was at every meeting. We never had a parent come in and say, you didn't let me come and speak to the teacher, or I wasn't part of the IEP, or, something negative. They were always offered, and it's written, and there's a book like that big with all of the policies, not just for the children, but for the parents as well. So I'm wondering if we do this, does that take away from the districts that are doing their own policies? We worked really hard to do the right thing for both the children and the parents. So how would that affect each district?
Thank you for the question. I am happy to hear that your district is already doing this stuff. So in the language, the only requirement is they have a policy. It's not dictating the method of saying you have to post it on the website and you guys are providing it, in the library or something like that. There's no requirement that you post something, or it's just that the board should consider this and this issue and create a policy for it. And by your testimony, it seems like the district that you were a part of already was following those best practices and had positive effects. And so I think that it's possible that this legislation, if passed, may have no effect on your district at all. It would only encourage the other districts that may not have such a I was saying expansive amount of policies regarding the opportunities of parents to be, or comprehensive, yes, comprehensive, robust. I'm getting a lot of help. Robust amount of policies that explain the parents' ability or encourage the parents' ability to take an active part in their child's education. And I mean, in the testimony, it seemed like that is not the case in all of them, and so I want to encourage all of them to be, I guess, as you said, kind of like a shining example that this is where we want you to be involved, right, in your parents' learning, and it would be hard to achieve greatness for those or good outcomes for those kids if you were not involved, kind of a thing. It's, I think, the general gist of the bill. So yeah, thank you.
May I have follow-up, please?
Sure.
So after the policies are made, they then go to the superintendents, and they have superintendent meetings with all of the superintendents throughout the state, and then they're all approved. And so I'm just concerned that we're sort of double dipping. You know, it's sort of, you know, mom says no, dad says yes. It just feels a little uncomfortable if most of the districts that I'm familiar with do that. And by law it says, you know, it's like a parent statement. You have to notify the parents, blah, 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 blah. So if we do this, I feel like we're sort of overstepping the educational standard. I can't think of a word, but does it make sense what I'm saying to you? No, it does not. I didn't think it would.
I mean, I have a question in what you just said as far as you were coming up with the policies at the local level and then they were adopted at the state level as far as like governing all of them?
Oh, no.
Okay.
Oh, I'm sorry.
That's what I was worried about. So you were, because it seemed like you were saying the state level has this overarching policy, and then we're making the local levels have their own separate policy, and that's where the double dipping happened. And so, but if that's not the case, then yeah, I just the local level can have their differing policies based on the needs of that community, and that will be completely in alignment with this bill, I believe. So thank you.
Okay.
Representative Altshuler.
Thank you, Madam Chair. I would like to discuss page 2 of the amendment, lines 11 through 15. And then reserve another question for page 4, line 7 and 19. So first, page 2 of the amendment, lines 11 through 15, an employee of the state, any of its political subdivisions, including, without limitation, any school board, school district, or school administrative unit, or any other governmental entity who encourages or coerces or attempts to encourage or coerce a minor child to withhold information from his or her parent who is not suspected of a criminal offense against the minor, and sharing the information would not impede an investigation of a criminal offense against the minor, may be subject to disciplinary action. So I read that, and red flags went up for me right out of the gate. We know that schools are a place where children have some real consistency, and they have some influential adults in their lives, and that when children are struggling with personal issues, that safe space to talk sometimes is outside the scope of their family. And I'm curious, and I want to know what protections in that paragraph allow for a child who is thinking about sharing their sexual identity with their parents, but fear that that will not be well received, and have a conversation with a trusted teacher, a trusted librarian. We're very fortunate in our district to have some incredible teen librarians for whom many children find a space of confidence and place to, exercise some thoughts. And if the parent subsequently learns that their child had a conversation with that other trusted adult, and that trusted adult didn't immediately tell the parent, thus breaking the trust of the child, it looks like a parent could bring that trusted adult to court. As of page 4,
Can we
line
answer
7.
that question first?
Right, it's all together, that a violation of the page 2, lines 11 through 15, in the example I gave, would result in violations and criminal charges on page 4, line 7, and also 19.
Representative Yokella, would you like to respond?
Thank you. I don't believe that the representative statement is reflective of the bill. There is no requirement that the person tell the parent that they reached out to the kid, or the kid reached out to them about anything. This only says that when they seek guidance from that trusted adult, the adult shouldn't say, well, just don't tell your parents.
May I follow up?
Yes.
So, where in this bill is there protection for that teacher when that parent who is not necessarily feeling as magnanimous as you are right now and says, what do you mean you told Mr. Jenkins that you wanted to, talk to us about your sexual identity? What do you mean they knew before I did? Why do they know before I did? So under this law, I can go to the Superior Court and file a claim saying that that Mr. Jenkins encouraged my child to be quiet, and now it's Mr. Jenkins' responsibility to protect himself against a claim that may or may not be true. How do you prove that a child who is now feeling very, very persecuted, which is probably why they went to a teacher or a trusted librarian or a trusted coach or another trusted adult to share some information, and this is outside the scope of a criminal investigation, and if that parent is angry, we have given them a space to press charges, to have a disciplinary letter added to a personnel file, to possibly be subject to being guilty of a Class B misdemeanor. This really, really puts a chilling effect on teachers, coaches, parents, librarians to develop those interpersonal relationships with children that encourages growth. You know, this is
Representative,
I find this chilling.
and you're entitled to your feelings, but in this bill, Section 2, line 11 through 16, it only discusses if that person encourages or coerces or attempts to encourage. It doesn't say anything about if the child goes to that person in confidence. If that person says, well, don't tell your parents, or anything to that effect, then the misdemeanor would take place. I think that, unfortunately, we tend to be a litigious society. And if the parents want to sue, they have every legal right to sue, but that has nothing to do with this bill. Thank you for your questions.
I have another one, if I may.
One more.
Yep.
Thank you.
We have children that are currently in emergency departments going through acute psychiatric crises, and a significant number of those acute psychiatric crises are from rejection of parents accepting their gender identity. And this
That has
puts-
nothing to do with this bill, ma'am.
I would say, respectfully, Madam Chair, I would say that this closes a space for exactly the kind of trusted adults that we try to cultivate in our communities, for children to be able to go to. And this tells all of those potentially trusted adults that it would be safer for them to shut that down and to not do that, because they could be written up for a disciplinary violation or possibly be guilty of a Class B misdemeanor. And that this is not in the best interest of children. This is in the best interest of parents who feel that they're out of control. And
Thank you for your thought-provoking comments, Representative. We do appreciate them. Any further discussion? Representative Long.
Thank you, Madam Chair. So a couple things. The fact that encourage and coerce. If I'm a coach that told one of my players that told me that they tried marijuana, and I didn't get to the parents quick enough, as a parent, I'm going to be upset, and I'm going to tell the coach that, yeah, I think you told him to keep it between us. You know, why would he go to you and not me? So this is encouraging that. And the bottom line is, I think this is all about election. I mean, whomever is in these school districts that aren't giving out this information, it's a matter of an election. You need to vote them out and put people in that are complying with what the law already requires with public information. So it's an election process. It's a warrant article, not a statutory fix, because I don't believe this is going to fix anything, and it's going to create more of an issue with courts and with our committee.
Thank you. Any further discussion? Representative Levesque.
So on page 2, lines 1 through 3, it talks about the parents' right to enroll them into any type of school, public or private, religious. That's already into statute with RSA 1931. The parent already has the right to choose how their child is taught, whether that's religiously or, I grew up in a town where we got to choose which high school we got to go to, because my school district did not have a high school built in town, and so we got to choose whether to go to one school or another, or we had a chance for 3. In those types of school districts, the parents always have the right to choose which school their child goes to, how they're taught. It's up to the parents, so that's already into statute.
Thank you. Representative Petrino.
Thank you very much, Madam Chair. And thank you, Representative Levesque, for your comment, because I was actually thinking the same thing. I was a high school teacher for 40 years, and I can tell you that as a matter of state law, Department of Education policy, and school district policies, most of what's in this bill already exists, and it's redundant. If it's not happening, it's happening on some occasions, not enough to justify state legislation. It really is a matter of those parents who have grievances going to the school and then going to the superintendent and then to the school board, and if they're not happy with what's going on, then vote them out. I can tell you in my town of Milford right now, there's a lot of contention going on, and there are a lot of people who actually have come forward and they're running for school board because they want to make changes in that school district. But what's happening in my school district is not necessarily happening in another school district where things are going fine. And again, I will tell you that most of what's in this legislation already is a matter of statute, New Hampshire Department of Ed policy, and local school district policy. And as a teacher of 40 years, I'll be honest with you, I supervised a department, and most of the complaints that I got as a department chair came from whether or not a child's grade on a test was fair or not, because maybe the teacher graded it wrong and, you know, you're being unfair to my child. Most of the issues that are here, I never ever witnessed in my 40 years. This bill really is not necessary. If there's a problem to be fixed, it needs to be fixed at the local school level.
Thank you, Representative. Any new information to come? Representative Altshuler.
Thank you, Madam Chair. On page 3, line 27, 28, and 29. In the center of line 27, if a parent is dissatisfied with the results of such an appeal, or such an appeal does not take place in a timely fashion as required by this paragraph, which is within 10 business days, the aggrieved parent may appeal the matter to Superior Court with jurisdiction over the applicable school district. So now, when a parent is dissatisfied with the answer that a trusted adult was providing a space for a child to explore and explore the ways to talk about something that's very personal to them, and then the parent sends a letter to the superintendent asking, how did this happen? Why did this happen? And the parent is dissatisfied with that report. Now the parent can take it to Superior Court. And I think we have learned over this past 2 years that that there are a number of parents who have no problem whatsoever jumping into court. And
Thank you.
I want to now. If I may. Oh, thank you. I think I have this. I had the honor of being part of a Boy Scout meeting in my town. I have a really, really active scouting community in the town of Stratham. And I was working this particular day with some scouts who were in 5th and 6th grade, and they were so engaged. And we did a mock hearing like this, and with a chair and a vice chair and a clerk and people sitting here to witness. And when we got to the end for the Q&A, one of the scouts said, Representative Altshuler, what are you doing in Concord for the trans kids? And the other students, the other scouts, did this. And for them, that's a silent way of saying, yeah, I agree with you. Yes, I want to ask that question too. Yes, please, I want to know the answer. And so, you know, I talked about a few things. But right now, this is what we can do for those kids. This is not a bill that is this is not a bill that is a Bill of Rights. for children. And this space on page 2, lines 11 through 15, doesn't help children. It actually creates spaces that can hurt them. We have children in New Hampshire who have been placed outside of our state in psychiatric facilities specifically because of gender identity. Their parents have placed them in facilities outside of our state because we say that that trans kids are perfect. They're our kids. And in no way should we be making space to create conflict for those children. So for my scouts, this one's for you. I will not support this legislation.
Thank you. Representative Belanger.
Thank you, Madam Chair, for recognizing me to speak on the matter. I think it's important to recognize that, to the previous speaker's point, this doesn't mention anything about trans or trans rights or anything along those lines. What it does mention is parental rights and parental rights in education. And as a parent, I believe, and as I stated to my community as well when we had this issue presented by a former member of this committee, that a child's issue of being transgender or not, and I'm not saying that is an issue, for the record, in case anybody wants to grab any mic clips. If they have this scenario and they need to go through that process, they have that right to go through that process. I am not disagreeing with that. But it is the parent's right that they should be informed in a joint, collective agreement to sit down and communicate and chat. Because I, as a parent, should never be left out of the decision that someone else is making for my underage child. And with that, I conclude my comments.
Thank you, Representative. I'll take one more, and then I'm going to move the question.
Madam Chair, you have
Representative Smith.
You have every right not to take my question. You as chair are in control, so if you would rather I not say anything, you should just say that.
That's not my intent,
Okay,
Representative.
Because I respect your right as chair. I particularly want to commend my very dear friend, Representative Rice, for asking Christina Dyer to prepare this document that was just handed out to us. I don't know if members of the committee had a chance to see this before today, but it is superb. It is, as usual, and I expect that kind of work from committee researchers. It's very well done, and I go through every section of 1431 as introduced, and there on the right is the documentation referred to by a number of our colleagues that says this is already in state and federal constitution, in state and federal law, and then also, as we know, since we believe in local control, or at least we say we believe in local control, whether we do or not, in local school districts. So that seems to me that it is at least redundant, if not almost insulting, to deny the existence of all of this language that already exists. And therefore, it is very hard for me to figure out exactly what the purpose of this legislation is, given that all this really exists, unless we want to make a statement, and I'm just not sure that legislation should be used to make statements. And I again thank you for the courtesy of letting me speak, and I want to commend both Representative Rice and the committee researcher for this excellent work. Thank you.
Thank you for your comments. With that, I will ask our clerk to call the roll on the amendment.
Representative Yokella.
Yes.
Representative Renzullo. Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes.
Representative Denise Smith.
Yes.
Representative Long.
No.
Representative Alicea. No. Representative Marjorie Smith.
No.
Representative Levesque.
No.
Representative Chase.
No.
Representative Altshuler.
No.
Representative Petrino. I will be voting no. Madam Chair DeSimone.
Yes.
8-7.
Thank you. Representative Yokella, do you have a motion?
Yes, I move OTPA.
And is that seconded?
Madam Chair, I second the motion.
Seconded by Representative Belanger. Representative Yokella, would you like to speak to that motion?
I believe enough has been said already. Thank you very much.
Thank you very much, Representative Yokella. Any further discussion? I think we've done well. I will, when he's ready, I will ask the clerk to call the roll.
Thank you, Madam Chair. Representative Yokella.
Yes.
Representative Renzullo. Yes. Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes.
Representative Denise Smith.
Yes.
Representative Long.
No.
Representative Alicea. No. Representative Marjorie Smith.
No.
Representative Levesque.
No.
Representative Chase.
No.
Representative Altshuler.
No.
Representative Petrino. I will be voting no. Madam Chair DeSimone.
Yes.
8-7.
Thank you. At this time, I'd like to take a 5-minute break so people can. Oh, yes. Will there be a minority report? Representative Long, and your motion will be. You're awesome. Thank you. There will be a minority report. And we'll take a 5-minute break to stretch our legs, or just please come back in about 5 minutes.
In your instance, they would have given, it's recording.
if the parents.
I think it fixes your concern, and I can agree.
No, I mean, I just think that it should be two, right? Consent to the guardianship. That's why I was saying, asking if they said it. It just doesn't seem like, it doesn't seem grammatically correct. That's all. That's the only question. I understand where you're trying to go. That's why I asked if they gave you that language or you read it up yourself. Because I'm just, grammatically, it's just like, with consent of the guardianship. Or like brought the case of guardianship or suggest, I don't know. But that's consent. Do you see what I mean? Of the,
Yeah,
of the
I'm
language.
sure necessarily that
I'm not sure. I mean, yeah, if we could ask, that would be. Yeah, how do you read it? It should be changed.
So for you to move back to your seats and for the other people to get back from wherever they went to. Thank you all for coming back so quickly. I encourage you all to please take your seats so that we can begin the next bill, House Bill 1518, relative to the requirements for appointed guardians. And I'm going to ask Representative Belanger if he has a motion.
I do, Madam Chair. Thank you. I moved ought to pass.
Do I hear a second?
I second.
Representative Nelson seconds. Representative Belanger, would you like to speak to your motion?
I do. I have an amendment, and I'd like to move Amendment 2022-0892H, and I would like to speak to my amendment.
Certainly.
Oh,
I second.
Representative Nelson seconds that. I'm sorry, I
second
didn't
it.
say that. You should have it, Representative.
I handed them out before. I had 15, so.
Go ahead, Representative Belanger.
Thank you, Madam Chair. So it was a little bit longer, this amendment, than I was kind of alluding to. But one of the things that was brought up during the first part of our first year session, as I brought forward another bill, was that during the guardianship and adoption, prior to the adoption process, there's no visit being done in a home. So, as promised, I brought forward this bill, and this is what you see before you today. So, the guardianship statutes and appointments go under RSA 169C and RSA 463. This requires that after the appointment, within 60 days, the guardians shall receive a home visit by a child care agency. Now, this is any agency that is approved by the Department of Health and Human Services and licensed by them to do such visits like home assessments during the adoption process, and very similar in that instance. The home visit, and this is where I was hesitant to add this, but I think this is good, as some parents may agree to the guardianship, that you may have the and this is so. The home visit may be waived if the parents give consent of the guardianship, which means if they agree to the guardianship and are not contesting it. Now, in the adoption RSA, you may ask for a waiver of the home assessment, and this is what my previous bill had done to reduce the restrictions on that. So there's still the ability to allow for the visit to be waived. The cost of the agency visit shall be paid for by the guardian. The agency shall visit within 30 days, issue a report to the court and the guardian, indicating the home is a safe environment for the minor child, or if unsafe, list the unsafe issue or issues to be corrected. Proof of the corrected issues shall be submitted by the guardian to the court and the agency within 30 days. If the guardian fails to remedy safety issues as referenced in subparagraph B, the agency shall promptly notify the court and the guardian for appropriate judicial action. Failure with this section without good cause shown shall be grounds for judicial review. So I think this is just, as simply put, a brief hour visit from an agency, max, minimal cost to this, just to ensure that kiddos are placed in a safe home, and knives aren't left on the counter, there aren't holes in the floor, it's not an unsafe living environment, it's not an inhabitable place to live. So simple as that, and yeah, that's it.
Thank you. Representative Smith, you have a question?
I do, thank you very much. I have a question for the sponsor. Where it says that the guardian must pay for the visit, I just am concerned about what happens if they're good guardians, we really want the children to be in, and because the concern is the children would be in much better shape in this particular arrangement than other alternatives, but an unspecific cost might be more than the guardian could bear, and there's nothing in here that indicates the ability to pay, and I'm just wondering if that's going to get in the way of a placement in the best interests of the child. Can you reassure me?
Absolutely. So the home assessment of during the adoption process is $1,100, and most agencies have a waiver that allow you to, or excuse me, a grant that allow, if you're a relative placement or provider, that you can ask for that grant, and it applies, and you no longer have to pay for that. Luckily, I fell under that grant, so we didn't have to pay that $1,100. I cannot speak to the agency or agencies as to what that cost will be, but I do not expect to see an $1,100 price tag for a brief report on whether a home is safe or not in discussions with those agencies.
Representative Chase.
Thank you, Madam Chair, and thank you for taking my question. It says here that a guardian shall file a report with the courts on behalf, with the courts before each review date. And is this going to be something that is going to be found, say, on the judicial website, that it's an actual report that you fill out, or is it just notes, hey, here's what we did, and what exactly is the report that the guardian has to file? The bill?
I'm not following. Can you kind of reiterate, please?
What line are you discussing,
Oh, okay.
Representative?
You know what? I'm sorry, because you amended the bill replacing Section 1. Never mind.
Thank you. Any further discussion? Representative Long.
So, my question is on the grants. I know Waypoint does it. It's $1,000, and they do have grants. However, they run out of grant money early because that's what people are going for first. And this is requirement, which I agree. Every home should be safe, and there ought to be a home a home safety visit. But I'm still battling with the cost to whom, and when it's waived, is there a cost at all? So the waiver is on the agencies. It's to do the waiver. Okay, it's not. So who does pay if a judge waives it? Who pays? The agency does it for free?
Is that it?
Yeah, it is more.
Okay. So when the home visit is waived, this is done at the judicial branch, or
Yep.
so that's that piece. If it's waived, there's no cost because it's been waived. You don't have to do it. It's not a requirement. If it's waived, it's no longer a requirement, so they're not paying for it in the first place. So I think that answers your question.
Okay, I get that. Yep. Follow up, if I may?
Follow up?
So it says on 21, the home safety visit may be waived if the parent or parents give consent. Is it parent or parents?
Well, so not as we know in this committee, not every situation and scenario is the same. Sometimes you may not be able to find said second parent, which is why it says parent or parents. So if a mom and dad agree, then that's fine. But if you can't find dad, and dad's not at the hearing, and mom agrees, there's no reason why one parent can't speak for the other parent. If the other parent decides they don't want to show up for a guardianship hearing, that they may lose guardianship of their child.
Can follow up?
Follow up?
So the scenario is what if they're both there but they don't agree? One wants a waive and one doesn't.
It doesn't say shall, it says may. And if they're both there and one of the parents agree, then they're contesting the guardianship itself. They're not contesting the home visit, which is a different scenario in and of itself, which means the waiver wouldn't apply in the first place.
Okay. But I'm thinking on the follow-up, if I may?
Absolutely.
Thank you. I'm thinking on the parental bill of rights, that may goes into a shall. So,
If I'm
All
being
right,
No.
if I'm being
I'm all
fair,
set.
those are two different bills, and we're talking about this one here. I kind of get where you're going with that, but in the event that one or both parents are there, in one of the references that we had suggested was that when parents are giving guardianship to grandparents or aunt and uncles, and they're agreeing to the guardianship, that's where the waiver may be waived, that the parent or parents are agreeing that this is the safe environment, this is a place where the kiddo should go, and we agree to that. But if they're contesting, as Representative Long had suggested, one or both, they're not contesting the visit, they're contesting the guardianship in its entirety, and that is a different issue, and that's what that would be done. If they're contesting the guardianship, that's done prior to the guardianship being put in place.
okay, thank you.
Thank you. Any further discussion? Representative Chase?
Thank you again. And I did find that area. It wasn't taken out of part one. It's still in your amendment. If you look at line 9, it says the guardian shall file a report with the court on or before each review date. A parent may file a statement or report with the court on or before each review date. So my question again is, what is this report? Where is it found? I was a guardian for my daughter for 7 years. I had enough things I had to file and look at to be her guardian. So I'm curious what this is, what does it entail, and does it have to be done, this says could be reviewed every 6, 12, or 24 months. So are you expecting a guardian to fill out this report and forward it to the judicial branch, I would imagine, or finding the file there and then having to do that 3 times a year if it's requested?
The only thing that's being changed in the current statute is the bold print. What you're reading is in the current law. and we're not looking to change that. Does that answer your question?
Not really, but it's fine. I understand what you're saying.
Uh-huh.
I do understand what you're saying. I just wasn't aware of that part of it, but my
Okay.
daughter also wasn't a minor.
Right, okay. You're welcome.
Madam Chair, if I may, just briefly.
Absolutely.
Thank you. So, my guardianship was for a minor, and you do have to fill out a 6-month report, and it's just a basic, simple. It's currently done right now in statute. We're not changing that, as the chair alluded to. It's every 6, 12, and 24 months, and that's just to make sure that everything is going hunky dory. Right? That's it. And like I said, it's already in the current statute. And that's just to make sure that the guardians are doing what they're supposed to and being guardians of a child. That is a minor. And I don't think it would apply to your case because this is strictly for this RSA. And if your child wasn't a minor, then that wouldn't apply to that specific RSA in the first place.
Thank you. Any more discussion? Seeing none, I'd like the clerk to call the roll on the amendment, please.
Representative Yokella.
Yes.
Representative Renzullo. Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes.
Representative Denise Smith.
Yes.
Representative Long.
Yes.
Representative Alicea. Representative Marjorie Smith.
Yes.
Representative Levesque.
Yes.
Representative Chase.
Yes.
Representative Altshuler.
Yes.
Representative Petrino. I will be voting yes. Madam Chair Disimone.
Yes.
15-0.
Representative Belanger, do you have a motion?
I move ought to pass as amended.
And do we have a second?
I second.
Seconded by Representative Nelson. Any discussion? Seeing none, I'll ask the clerk to call the roll.
Representative Yokella.
Yes.
Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes.
Representative Denise Smith.
Yes.
Representative Long.
No.
Representative Alicea. Representative Marjorie Smith.
No.
Representative Levesque.
No.
Representative Chase. Representative Altshuler.
Nope.
Representative Petrino. I will be voting no. Representative Renzullo. Okay. And Madam Chair Disimone.
Yes.
8-7.
Minority report. Representative Long? There'll be no minority report. Do you want to do consent? The numbers are too close, yeah. Can't do consent. Whatever. Okay, so. Yeah. Thank you. I love the fact that I'm able to rely on the more seasoned representatives.
Actually, Madam Chair, what I was going to say at the end of this, but I'll say now in light of your comment, is that I would like to congratulate you. If this is the first time that you have chaired a committee, it's the first time that you realize how many bits and pieces have to be in the air at the same time, and you've done a wonderful job.
Why, thank you very much. I really appreciate that. That said, let's hope I do just as well on the next two bills. Oh, thank you. It seems that the clerk looks like he's ready for the next bill, so. If it was here, it was passed out. I don't see it. I don't either. Representative Smith, I've just been tested. I hope I passed the test. The amendment that the sponsor of the next bill has not reached us as of yet, so we're having that printed so that you can all go over it. And in the interim, we'll go on to the next bill. It is an amendment by the sponsor. And one of the committee members will make the motion to accept the amendment. No, I think it's one line.
I thought amendments had to come from within the committee.
It was not.
I mean, it will be. It's not going to be introduced by the sponsor.
It won't be introduced by the sponsor. It will be introduced by it was only drafted by the sponsor. It's not just one line. Today. Or tomorrow. And I don't want to come back tomorrow for one bill. I am. Okay, can we come to order, please? Yes. Yay. So we have a Spillane de Simone amendment that I'd like you to look at. When we open this bill, I just got so excited. So. Yep. Okay, so we'll now open House Bill 1612, relative to the confidentiality of reports made to the Division of Children, Youth, and Families and requiring guardians ad litem be appointed in certain instances. Representative Yokella, would you like to make a motion?
I make a motion of OTP.
And is that seconded?
Second.
Seconded by Representative Belanger. And Representative Yokella, would you like to speak to your motion?
Yes, I'd like to move amendment 2022-0842H.
And is that seconded?
Second.
Representative Belanger. And everybody should have a copy of the amendment.
It looks like this. That's not the.
It was just passed out. Oh.
They might have more on that side.
They might have more over there, Representative Smith. They're on the far end. Thank you.
So do you want me to speak to it?
Representative Yokella, would you like to speak to the amendment?
Sure. The amendment removes the GAL issue, which was weird to be added in the first place. And then it also changes the requirement that the reports be could only be made if they gave their name, address, and phone number to that the reports may include that information, and it also allows the department may inform the complainant that that complaints made maliciously or with intent to harm could be subject to criminal or civil penalties, and also addresses the court's concerns as far as the effective date.
Thank you. Any discussion, or do you just need more time to digest? Representative Altshuler.
Thank you, Madam Chair. I would like to reiterate some information that we all received on Monday, the 21st at 7:19 p.m. from the New Hampshire Coalition Against Domestic and Sexual Violence. And on page 2 of that, for those who have not reviewed it, as a reminder, often victims who are trapped in a domestic violence situation make anonymous reports to DCYF against their abuser, whom they have witnessed inflicting abuse upon their children. In fact, there are many reasons that victim parents may be afraid to report abuse or engage with child protection service workers. Victims may fear that CPSWs will tell their partner, or that what they say will get back to their abuser, that they will be blamed or not believed, or that their children will be taken away. The ability to make anonymous reports ensures that they can get the help they need without placing their safety at further risk. It also alleviates the barriers that victims need to overcome to get support.
That's correct, and that's what this amendment speaks to, is the fact that anybody who calls does have the opportunity to make their call anonymous.
What I am, what is not anonymous is that the reports may include the name, address, or phone number of the person making the reports. So there now is
Well, they may, but if the person is anonymous, Representative, then they're anonymous, and there'll be no name to put in the report.
being, with respect, Madam Chair, being able to make reports safely to DCYF regarding suspected or known child abuse is an important part of responding to and assisting families escape violence and abusive situations. Opening a door for a possible disclosure of name, address, or phone number is a chilling way to put another barrier in front of victims of domestic violence.
I agree with you, Representative, that it is chilling. It is absolutely unnecessary in some cases, and that's why the amendment removes the fact that a person would be required to give their name, phone number, address, or any other identifying information. The
Online,
original bill required it, but not the amendment. And we're speaking to the amendment.
I am speaking to the amendment. On line 20 of the amendment, the department may inform the complainant that should the complaint be made maliciously or with intent to harm, the complainant may be subject to criminal and civil penalties.
That is correct, and that would only be in the case that the particular person gave voluntarily their name. If you don't give your name, there's no way to know who you are.
With respect, Madam Chair, that's not how the system actually works in real life. So
Thank
I think
you.
that this sets up a barrier for people trying to access family violence prevention specialists in our state, and this amendment does not address those issues.
Thank you. Any other information? Representative Belanger?
Thank you, Madam Chair, for recognizing me, and I just want to point out that I spoke with the bill sponsor about my concerns about the initial bill in the first place, and I am very happy that this amendment has come forward. I think one of the things that I said was it shouldn't be a requirement to have to provide, but that you should, and I think that's what this bill does. So it says the reports made to the department may include the name, address. It doesn't say it has to. It doesn't say it shall. It says it may. And the department may inform the individual that if you are doing this on purpose to be malicious, right, as it says, that you are subject to criminal and civil penalties. I mean, as somebody who has made reports to DCYF, I think this is a major step in the right direction, and I support the ought to pass motion with amendment.
Thank you, Representative. I spoke with the Director, Joe Ripsum, yesterday concerning the amendment. He was not on board with the bill itself, but he said that the amendment made it exactly what it should be, and he supported the amendment and therefore supported the OTPA motion. So I feel very comfortable with that. Representative Long.
Thank you, Madam Chair. So in essence, this is given DCYF the latitude of asking for a name on a complaint. Is that correct?
Well, sure, absolutely. We already have that now, but it also gives the opportunity for the caller to say, I choose not to give my name.
Right.
Without repercussion.
Okay, thank you. Could I follow up on that one?
Certainly.
So what I'm thinking is that down the road, DCYF is going to know what complaints that they want the complainant, because they're thinking maybe it's going to be false, or maybe this person has done this before and it was a false complaint.
Well, I can't
And-
answer to how a person who takes the call is going to think.
No, it wasn't a question.
Okay, thank
No,
you.
it's just I'm just thinking. I'm thinking out loud.
I do that a lot.
So, yeah, I mean, this would be nice to ask Mr. Ripson if it would be nice to have him here to, because it does give him the authority to ask a complainant for their identification. That's clear, and I'm okay with that because they probably get a lot of calls from the same people, and they can recognize the voice, and they could ask that. Could you give me your name? And by the way, false information you could be liable. But I'm trying to. I don't know if that's good practice for DCYF to. With confidentiality, it appears to be working. I mean, yeah, the people are putting in false claims. That's what's happening. So this is looking to fix that, and I'm not sure if this does. But I lean, without having Mr. Ripson here, I lean towards thinking that this is putting a strangle on the confidentiality reporting. Because if I call in and I want to be confidential, and I'm being asked, could you give me your name? Well, I'd like to be confidential. Okay, we're not taking your complaint. So, yeah, I just have too many.
Okay.
I'm uncomfortable with this, but that's me.
Representative Yokella.
Thank you. This amendment doesn't. Well, it was my understanding from the testimony from DHHS that they actually encourage people to give information so that they can follow up, because the person doing the investigation isn't the person answering the phone, and so they want to be able to get more information when they're doing the investigation and have more time to investigate. So they prefer people to give that information and not do it anonymously, do it confidentially. And so there is already a practice of trying to get that information so that the investigator could follow up. And so this is the proposed bill proposed to change that. And this amendment is going back to the may collect that information option, and that is currently practiced. And so there is, when we get to the rest of the bill that is not changed by this amendment, I think some of the concerns as far as releasing the names of confidentiality is addressed in the actual bill and not a subject of this amendment. So I don't want to speak to it because that would be not allowed. But I think that this is completely allowing for anonymous reporting, confidential reporting, just as is the practice now. So this is more pulling back the step for the GAL and the requirement that that eliminated the anonymous reporting. And so it's pulling back those and still leaving the rest of the bill in place. And so I think that is the goal of this amendment. So thank you.
Thank you. Representative Petrino.
Thank you. I'll be honest, I'm a little confused, because if I'm going to call DCYF and give a false report, and then the person on the other end of the phone says to me, would you like to give your name and address, sir? I'm going to say no. So I don't know why we need this, because it doesn't make any sense.
Thank you. Representative Altiller.
Thank you very much, Madam Chair. In the state of New Hampshire, everybody over the age of 18 is a mandated reporter for any suspicion of child abuse or neglect. Every person over the age of 18 is a mandatory reporter. And we have created an environment in New Hampshire that is unique from other states to be able to get help to children when they are experiencing abuse or neglect. And one of the things that has helped us is being able to make anonymous reports, because we know that retaliation for making reports is a significant fear for family members who may be witnessing abuse within their family. It's a significant barrier and fear for neighbors who want to make a report but genuinely fear retaliation from their neighbors. And changing our statute that instead of it being child first, it's now becoming reporter first or possible abuser first, I think is unnecessary, first of all, and actually hurtful. We know that when a report comes in, that a child protection worker is dispatched to do a minimal facts interview. And during that minimal facts interview, some of this information can be gleaned. If as a neighbor, I make a report and I want to make an anonymous report because I genuinely fear retaliation from my neighbor, and the librarian makes a report and a teacher makes a report, that's 3 reports. And we have been encouraging that kind of activism in the state of New Hampshire to help children. And we aren't even getting to all of them because our child advocacy centers are absolutely overwhelmed with these forensic interviews for children that are being abused and neglected. We can't get to all these kids. We don't have enough people right now. And we're now putting in a barrier for people to be able to make that report. If there is an impression that you will have to leave your name, or that perhaps if you don't leave your name, your report will not be handled with the same seriousness that another report is, then we're slowing down and we are silencing the very people we need to speak up. Having just seen this amendment less than 10 minutes ago, I think that it creates an environment where people will believe that it's a default to give the name, and that is not what we want in this state at all. We want as many people as possible to speak out on behalf of children. Thank you.
Thank you. Any further? Representative Long.
Thank you, Madam Chair. I'll be quick. I'm wondering what my liability will be if I'm mandatory to report, so I call to report. They ask me for my name, and I say I'd rather be confidential, so they're not going to take my report. I'm assuming, right? Is that what this says?
No, that's not what it says. It says you have the opportunity to ask. No, not at all.
But I am not getting
Nobody
this at all.
is ever going to say that you're a dumb person. Quite the opposite, Representative. Representative Smith.
Thank you, Madam Chair. I can only speak to what happened to me when my DCYF call went in. They gave their information, and DCYF would not give me the information on who called. I figured it out on my own, but they never told me any of the information. So, yes, you may give your name, but that doesn't mean that the person that is being complained about is gonna ever know who called. They may figure it out like I did, but it's not a concrete, it didn't come from DCYF.
Thank you.
Thank you.
Representative Yokella. Any further questions or comments? Seeing none, I'll ask the clerk to call the roll on the amendment.
Representative Yokella.
Yes.
Representative Renzullo. Representative Nelson,
Yes.
Representative Belanger,
Yes.
Representative Healy,
Yes.
Representative Green,
Yes.
Representative Denise Smith, Representative Long,
No.
Representative Alastair, Representative Marjorie Smith,
No.
Representative Levesque,
No.
Representative Chase,
No.
Representative Altshuler,
No.
Representative Petrino. I will be voting no. Madam Chair, DeSimone,
Yes.
8-7.
Representative Yokella, would you like to make a motion?
To pass as amended.
Would you like to speak to that? Oh, let's get a second.
Second, Madam Chair.
Seconded by Representative Belanger. Would you like to speak to your motion, Representative Yokella?
Yes, thank you. As I alluded to before, still inside this bill as amended, it does say that under no circumstances shall the identity of a complainant who makes a report of suspected abuse or neglect in good faith or pursuant to RSA 169C:9 be released. And so speaking, so that is specifically stated that it should not be released and will be kept confidential. And the rest of the bill is just the purpose of the bill mainly, now that it's amended, just instead of changing change from anonymous possible to not anonymous possible, now that that is removed, the only thing really that this bill does is ensures it adds New Hampshire to one of the states that actually has a penalty for not doing a report in good faith. And so I believe that that is important, even though we're asking them to do it in good faith. Having a rule that says that they shouldn't be making false or making false statements, and that there's a penalty on the books for that. I think that is of value, and hopefully will deter even those people that still have the option to make that false report anonymous and just hope that no one investigates and finds out who they are. Will be dissuaded from making those false reports. So thank you, and I hope that everyone will support this bill as amended. Thank you.
Thank you, Representative Yokella. Representative Altshuler, you have a comment or a question?
Thank you, Madam Chair. I have a comment with
Okay.
relation to the vote we're about to take.
Sure.
Well, I would like to think that this all is made in good faith to protect people, but I don't see it. I see it actually being a deterrent for people to make complaints, because our statute says anyone over the 18 who just suspects that there is child abuse or neglect is mandated to make a report. And the reason we do that is because one person may see a little bit and another person may see a little bit, and all together we get a full picture. If we throw this amendment in this bill, I think creates a barrier where people will really reconsider whether they make a complaint or not, because they will feel as if they will have to have investigated and have a provable conclusion to even make a report, and that's not the intention. That's not the intention of our child reporting laws. And there is actually, while you can make an anonymous report, if a case goes to trial, all that comes out in discovery. All of that comes out in discovery. So this is setting up a barrier, like, wait, before you go any further, just so you know, you might be prosecuted criminally or civilly for making this complaint or for giving this report. And with 1 in 3 women in New Hampshire experiencing sexual violence, and the majority, nearly 80% of them, before they turn 21, we don't need any barriers at all, perceived or otherwise, to report child abuse. So I think that this is I think this is unnecessary and actually will hurt the process. So I encourage my colleagues to vote no, and to not hamper the already very difficult work that our Department of Youth and Families has to do.
Thank you. Any further discussion? Seeing none, I'll ask the clerk to call the roll.
Representative Yokella.
Yes.
Representative Renzullo.
Yes.
Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes?
Representative Denise Smith. Representative Long.
No.
Representative Alicea. Representative Smith. Marjorie Smith.
No.
Representative Levesque.
No.
Representative Chase.
No.
Representative Altshuler.
No.
Representative Petrino. I'll be voting no. Madam Chair, DeSimone.
Yes.
8 to 7.
Minority report. Who?
Will there be a minority report?
Yes, Madam Chair.
Representative Altshuler, will you be preparing that? And your motion will be?
My motion would be ITO.
Thank you. The next bill will be House Bill 1614, requiring the recording and storing of digital video in all state-funded juvenile detention facilities. Representative Belanger, do you have a motion?
I sure do, Madam Chair. I motion. I cut myself short. I'm sorry. I motion not to pass.
And do you have a second?
I second.
It's been motioned and seconded. Would you like to speak to your motion, Representative Belanger?
I do. Just briefly, so I did ask the director yesterday when I spoke with him if what his stance was on this issue, and he did agree. He supports this bill, and I ask that we support the ought to pass motion.
Thank you. Any discussion? Representative Altshuler.
Thank you, Madam Chair. Oh, hello? Yeah, there we
Yep.
go. So on line 6, it says, or lines 4 through 6, each facility paid for in whole or in part with general funds. What about children who are being detained in other states? Our children.
Well, we don't have any.
We do. We have children who are being detained in Vermont. We actually do.
That was not the
We
testimony.
have children being detained in Florida.
Representative Belanger.
Thank you, Madam Chair, for recognizing me. That representative is factually incorrect. When there are no students at SYSC being held outside of New Hampshire, Vermont itself does not have a facility that is locked and or secure. Vermont sends their students who are secure and or detained to our facility in Manchester, also known as SYSC. This is referring to juvenile detention facilities. When you're referring to Beckett Family of Services, who may have out-of-state homes, they are not juvenile detention facilities. Thank you.
Representative Smith.
Thank you very much, Madam Chair. When I read the bill, it indicated that those cameras were not to be every place. They're only to be in certain places. And I understand and value the importance of privacy. Excuse me, please. But I have for 15 years wanted to close Sununu Center because of the rampant abuses that were taking place there that were denied. And am pleased that we might be moving in the right direction there. But I am concerned about how we balance the right of privacy for the detainee with our obligation to be sure that the detainee is not being subjected to inappropriate behavior in a location in the facility other than those specified in the bill. And can you help me see my way to vote yes on this?
Representative Yokel, would you like to respond?
Yes, thank you. So the in the bill it says that the activity in all common areas shall be recorded, and it said areas requiring privacy pursuant to state and federal law or regulation shall be exempt from this recording obligation. So we're recording everywhere that we're allowed to record. And so if something is happening in those places that we're not allowed to record, obviously that is still a concern, but it would need to be addressed elsewhere. And if that was then repealed, then this automatically would be reflected in this bill because they would be no longer required by those state or federal laws that those areas would be protected.
Representative Long.
Thank you, Madam Chair. Yeah, I like the concept of this. I want to see it work. But I question each facility paid for in whole or in part with general funds. So that would be the Manchester Police Station would be required when they're dealing with a child to have a recording. I just want to be clear on that, correct? Because it's because they do get some state funding for different programs, juvenile and adults. And with respect to, I did ask the question to Representative Edwards, and he did say that it was New Hampshire specific only, but I didn't see where, because I'm thinking of a mental health secure setting. We don't have, we often run out of rooms here, and they're sent elsewhere. They are detained. They are secured and detained. But he did say that it was New Hampshire only. I don't see where it says New Hampshire only in here, but I did ask him, and he did say this is specific to New Hampshire only. So,
Representative Yokela.
Thank you. So mental health treatment, unless it's is not detaining someone, if they're in need of treatment, and the reason, as was expressed by DHHS commissioner, was that there is no detention happening out of state. So there is, that doesn't mean that people aren't receiving services out of state, but the detention is not happening out of state. And so it isn't specifically stated in the bill that it's only New Hampshire, but it is in practice, because that's where our detention, our secure detention is, that it would only be in the state, right? But if we, in the future, contracted with someone to do an out-of-state, then we would need to ensure that that they are capable of providing the protections that we're trying to give, I believe, in this statute.
Thank you.
so
Follow-up,
again.
Representative.
So your statement is saying that the commissioner of DHHS is saying that there is no one detained out of state.
That was
Mr.
his
Chairman,
testimony.
The commissioner, Shabonet, Laura, I don't recall.
No.
Shabonet.
No, it was the DH.
Uh,
Ripson?
Commissioner
Oh,
Ripson.
DCYF.
Yeah.
Okay,
Yeah.
I thought you were saying DHHS.
Sorry.
so. Okay, okay.
Representative Alschuler.
Thank you, Madam Chair. So I need to clarify, because there's a lot of there seems to be a little bit of a miscommunication. We have children who are out of state. We have children in Massachusetts. We have children in Vermont. We have children in Florida. We have children in Wisconsin who are all placed out of state for various reasons, not the least of which is that New Hampshire cannot meet their needs. When those children come in contact with juvenile justice in the state they are in, they're still our kids, we're still paying for them, and we cannot legislate what another state does with their juvenile justice procedures. And I fear, while I don't dislike the intent of this bill, as a matter of fact, I think it's a really great idea. But what this does not, this will set us up for parents, New Hampshire parents whose children are placed out of state, and then have encounters with the juvenile justice system of the state they're in. Now parents are saying, well, it's a New Hampshire kid being paid for with New Hampshire money. I want that recording. And we can't compel the state of Massachusetts to do that, nor can we compel Wisconsin or Florida or Vermont. So I think that there's a big gap here that is actually a problem in the making. And like I said, if this were New Hampshire specific, I'm all about it, but it's not. And so we are opening a window for a lot of problems, not the least of which are the parents who are very, and there are a lot of them who are very upset that their children are placed out of state. They want their kids in state. And this, because we can't meet this statute, would actually end up giving them a really good case for bringing them in. And we can't meet those kids' needs right now. So I just want to put that out there. I'm not against this bill in its intention, and I think it's made in good faith. There's a big gap.
Thank you. Representative Yokela.
Thank you for recognizing me. And in response to the previous speaker, it says each facility paid for in whole or in part with general funds from New Hampshire. So if just because maybe we have someone providing services at a facility that's not a detention facility, and say if they get in trouble and they get moved to another facility, that's a facility that we are not paying for with our general funds, and so it would not be covered under this law. If you're in Wisconsin and you're a kid and you get arrested, that doesn't mean that New Hampshire is paying out of general funds to give money to the jail that is housing that kid. So I think that there's that the example that you gave is not the example, I think it's a misunderstanding this first sentence, that the facility has to be paid for in whole or in part with general funds. So I'm not sure that case that you gave as an example would actually be accurate under this bill. Thank you.
Thank you, Representative Belanger.
Thank you, Madam Chair, for recognizing me. So I want to talk about two things. Number one, we're talking about detention, not a group home, which are two completely different entities. And so insinuating that we have students detained in juvenile detention centers is factually incorrect. We do not, out of state, we do not detain any New Hampshire under age 18 residents out of state. They might be at a group home. Again, very different things. So let's make sure that we're providing factual information. Detained is defined by before trial. Committed means that you have had a trial, a judge agrees that you did something wrong, and you are now committed to SYSC, for example. We're talking about a detention center. We're getting hung up on a word here. Keep that in mind.
Thank you. Representative Alicia.
Thank you, Madam Chair, for taking my question. I'm not hung up on a word, but I feel like I'm Negative Nancy. So the people that Representative Altschiller, I believe, are speaking of, that are out of state, the children, they're not named as being detained. It's generally for treatment. They use a different word. So that's the first thing. So I know factually she's not telling a story because I house some of them. Secondly, for me, I really think it's a good idea. However, for example, the Sununu Center, cameras can be everywhere, but they can't go in the bathrooms with the children. Where do things happen that there are no cameras? I mean, it's like policemen wearing cameras, and then all of a sudden you see blank. Oh wow, what happened? Oh, they didn't turn their camera on. So I think it may help in a lot of ways, because maybe someone who's abusing someone doesn't realize where all the cameras are. But in other ways, the persons that have taken the time to figure out where all the cameras are going to go to a place where they're not going to be seen and they can't be filmed. And that's really scary to me. I mean, it's just like in the schools have cameras too, but they don't have them in the bathroom. But a lot goes on in the bathroom. And if I may, Representative Yokella, why are you giggling? Are you giggling at something that I said?
I'm wondering if your position is that you want cameras in the bathroom.
I did not.
It seemed
make
like
that.
you were implying that
Absolutely
it was
not.
a problem that we weren't going to be able to record in the bathroom.
Absolutely
Okay.
not.
Representative Long.
So, with respect to detention and commitment, so we do have children detained out of state. When they get arrested out of state, they're detained. If they get arrested in Massachusetts, they're detained in Massachusetts. Okay? No, wait a minute. Let me finish. I sat here and listened to all of you. We don't have anybody committed in out-of-state facilities, in a secure out-of-state facility. So, you know, so that's, you know, I'm not seeing in this, and I just today brought it to my mind, having that discussion. These are just detained minors, securely detained, not committed minors. Right? Am I confusing that?
You're not confusing that, Representative. What this bill is saying is if a minor is detained in the state of New Hampshire, in a facility that we pay for, we cannot control what Massachusetts laws are. We cannot control what any other state is doing. We can only control what we pay for and what happens in our state. So I think that's where the confusion may be. We do have kids that are in facilities out of state, but they are not being detained in facilities that we pay for. We're only talking about the kids that are detained here in this state and facilities that we pay for. Does that help you?
I hear that, but I don't see it.
Okay. Representative Belanger.
Thank you, Madam Chair. Respectfully to Representative Long's point, anyone who is sent or is in another state who is attending another facility or treatment center, they are not detained. Detained is again defined before the trial. We can't detain kids out of state. It's why they go to SYSC. They're waiting for their hearing. There are no detained residents out of state. I just want to make that abundantly clear.
Thank you. Representative Yokella.
So I think I understand Representative Long's point in that if a person that is paid for at a community or like a group home out of state gets arrested and they're detained in that state, it's potential that they are not going to be detained at the group home that we pay for. They're going to be detained at whatever facilities that they have. And those facilities in Massachusetts or Wisconsin are not paid for by New Hampshire. And so that would not fall under this law because the very first part of this law says each facility paid for in whole or in part. And so therefore, just because they are detained does not mean that they are detained in a facility that we pay for. If they sent it to us in New Hampshire, then it would be a facility that we pay for. But we're not paying for the detention facilities in Maine or Massachusetts or any other state, right? Okay, thank you.
Any further discussion? Seeing none, I'll ask the clerk to call the roll.
Representative Yokella.
Yes.
Representative Renzullo. Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Healy.
Yes.
Representative Green.
Yes.
Representative Denise Smith. Representative Long.
Yes.
Representative Alsair. Representative Marjorie Smith.
Yes.
Representative Levesque.
No.
Representative Chase.
Yes, excuse me, yes.
Representative Altshuler.
No.
Representative Petrino. I will be voting yes. Madam Chair Desimone.
Yes.
12 to 3.
For the most part, our work is done. I want to thank all of you for your indulgence. And I want to thank all of you for your very good comments. It's brought a lot to light. It's all of your comments are not falling on deaf ears. We've listened to all. Who is anybody going to do a minority report for the last bill? No. It really is a pleasure to work with so many wonderful people who have so many thoughts that may be different from each other, but they're good thoughts. And thank you for working so hard today.
Is there any side that you prefer more working?
As with my children, I don't have a favorite. We will adjourn.